Real estate principles. Unit 12. The Landlord and Tenant. Learning objectives. When you have completed this unit, you will be able to accomplish the following. Define the types of leasehold estate. Describe how to create a leasehold and when a written agreement is necessary. Explain the essential terms of a residential lease. List the obligations of landlord and tenant and remedies available to each. Identify two of the California laws that prohibit housing discrimination. Describe how a lease is terminated. Identify the important elements of a rent control law. List the duties of a property manager. Key terms. The leasehold. A lease is a contract that conveys an interest in real property from one person to another. Any form of real estate ownership can be leased. Most frequently, a lease transfers the use of property without transferring outright ownership. The use can be occupancy only, or it can include the right to remove such property assets as oil, gas, or other minerals from the surface or subsurface of the land. The California Civil Code, beginning at Section 1940, governs situations in which a person hires real property. Tenants, leasees, boarders, lodgers, and others, but not guests at hotels, are included in those provisions, which will be mentioned throughout this unit. The leasehold. The owner of a leasehold has exclusive right of possession of the real estate, land, buildings, or both during the lease term. The lease is the instrument that sets the conditions of the occupancy. The leaser, landlord, the property owner, is someone who owns an interest in real property. The leasee tenant is someone who acquires use and possession of the property for a fixed period. Rent is the consideration paid by the tenant to the landlord in exchange for use of the property. Because they are more familiar to most people, the terms landlord and tenant will be used throughout the rest of this unit, instead of the terms lessor and leasee. The leasehold as property. Historically, a leasehold estate was considered personal property. Even though a leasehold estate conveyed possession of real estate, it was a personal property right rather than a real property right. This meant that important protections available to real property owners, such as that provided by what is referred to as the anti-deficiency law, were not available to holders of a leasehold estate. California law now provides that an estate for years, leasehold, generally is treated as real property in giving constructive notice of the existence of a leasehold by recording. Determining the priority of lien claimants. Determining the legal rights and remedies of the parties when an estate for years is hypothecated by a mortgage or trust deed, and applying the anti-deficiency law. The types of leasehold estates. Estate for years. An estate for years is a leasehold created by landlord and tenant for a particular period. The period could be a fixed number of years, months, weeks, or even days. An estate for years always will have a definite termination date that the parties agree to before the lease begins. No termination notice is required. Estate from period to period. An estate from period to period is also called a periodic tenancy. At the end of the lease term, if the tenant offers an additional rent payment and the landlord accepts the payment, the lease is renewed for an identical period. The lease continues from period to period until one of the parties gives notice of termination. Periodic tenancies usually have month-to-month terms. If no lease term has been specified by landlord and tenant, a month-to-month tenancy will be presumed for most real property. Exceptions are lodgings and dwelling houses if there is no local custom as to lease term. Other exceptions are agricultural or grazing land, where a one-year term is presumed. Estate at will. In the early days of the common law, an estate at will was one that could be terminated by either landlord or tenant at any time without the consent of the other party. California and other states now have statutory notice requirements that must be met by either landlord or tenant to terminate a tenancy. In addition, the landlord's acceptance of rent creates a periodic tenancy. For these reasons, a true tenancy at will now is uncommon. However, one might be created accidentally or unintentionally. If that occurs, the statutory notice requirements must be met by either landlord or tenant. Estate at sufferance. An estate at sufferance is created when a tenant remains in possession at the end of the agreed-on lease term, without consent of the landlord. The tenant in possession under an estate at sufferance is called a holdover tenant. An estate at sufferance is also created when a tenant gives notice of intent to vacate but stays on after the date specified in the notice, again without prior consent of the landlord. Unless the tenant pays rent that is accepted by the landlord, creating a periodic tenancy, the landlord can give notice of termination under an estate at sufferance at any time. For this reason, the estate at sufferance is considered the lowest, least valuable estate of tenancy. Creating a leasehold. An agreement to create a leasehold estate that is to terminate more than 1 year following the date of the agreement, even if the lease term is for less than 1 year, must be in writing. Practically speaking, both landlord and tenant benefit from a written lease agreement no matter how long the term. Even though only the landlord or the property manager need sign the lease, the tenant can accept the lease terms by occupying the property. Both parties should sign to avoid misunderstandings. A variety of lease and other forms are also available to members of the California Apartment Association through its website, caanet.org. It is important to remember the following characteristics of every lease. A lease, whether oral or written, is a contract. As such, it must follow contract formalities. Parties to the contract must have legal capacity, and there must be an offer by one party that is accepted by the other. The contract must have definite terms and a lawful object and must be supported by sufficient consideration. If the contract is written, it cannot be changed by oral agreement of the parties. Contract modification does take place, however, if both parties perform in accordance with orally agreed on changes. Any pre-dispute contractual waiver of the right to a jury trial is constitutionally invalid. A carefully drawn lease agreement covers the subjects discussed next. You can remember them as the 4 P's: parties, property, period of time, and payment parties. The lease should identify the landlord and tenant, as well as any other persons expected to occupy the leased premises. Property. The property should be adequately described and its allowable use specified. As of July 1st, 1999, all written leases and rental agreements and contracts for sale of residential real property must contain a specified notice regarding the database maintained by law enforcement authorities that contains the locations of registered sex offenders and other related provisions. Period of time, lease term. The date on which the lease is to commence and the length of the lease term always should be mentioned. By law, property located in a city or town cannot have a lease term longer than 99 years. The 99-year limitation also applies to land leased for the production of oil, gas, or other hydrocarbons. Lands used for agricultural or horticultural purposes cannot be leased for longer than 51 years. The probate court determines the maximum lease term for property belonging to a minor or an incompetent person. If no lease term is specified for a dwelling, the length of time for which rent is paid is considered the lease term. A weekly rent payment implies a weekly term. If there is no specified time to which the rent applies, a month-to-month tenancy is presumed. The tenant must receive a copy of the lease or rental agreement within 15 days of executing the agreement. Annually after that, the landlord must provide the tenant with a copy of the lease or rental agreement within 15 days of the tenant's request. If the rental agreement is oral, the landlord must provide the tenant with a written statement setting forth the information required under the new law. Payment. Rent is the usual consideration paid for possession and use of leased property. A tenant is obligated to pay rent after taking possession or after the period of the lease term begins. Rent can be made payable in advance of the actual possession or beginning of the lease term, or at any other agreed on time. If the parties fail to stipulate when rent is due, California law provides that it will be payable at the end of the lease term if the term is 1 year or less, or as local custom dictates. All residential leases and rental agreements must include the name, telephone number, and address of the person or entity to whom rent payments are to be made, and if rent may be paid personally, the usual days and hours the person will be available to receive rent payments. The landlord can choose not to include this information, but only if the landlord expressly includes in the lease or rental agreement specific information that will allow the tenant to pay by direct deposit into the landlord's account or by electronic funds transfer. The lease or rental agreement must also include the form by which rent payments are to be made. If the address provided by the landlord does not allow for personal delivery, it is conclusively presumed that the landlord received the rent on the date posted, if the tenant provides proof of mailing to the name and address provided by the landlord. Price gouging is a crime. Penal Code Section 396 makes it a misdemeanor to sell certain goods and services for a price that exceeds by 10% the price charged for the good or service immediately prior to the proclamation of a state of emergency by the President of the United States or the Governor, or the declaration of a local emergency by the executive officer of a city or county resulting from an earthquake, flood, fire, riot, storm, or natural or man-made disaster. The law applies for a period of 30 days following the declaration and includes rental housing with an initial lease term of no longer than 1 year. The 30-day period may be extended for additional 30-day periods as needed by the official or governing body if necessary to protect the lives, property, or welfare of citizens. Violation of the law is punishable by imprisonment in a county jail for up to 1 year, a fine of up to $10,000, or both. In addition, violation of the law will be considered an unlawful business practice and an act of unfair competition which can result in additional cumulative remedies under the Business and Professions Code or other laws. Security deposit. A security deposit is an amount paid at the start of the lease term and retained by the landlord until the tenant vacates the premises. All or part of the security deposit may be kept by the landlord at the end of the lease term to cover costs of any default in rent payments by the tenant or reasonable costs of repairs or cleaning necessitated by the tenant's use of the premises. The security required for a rental of residential property includes any charges imposed at the beginning of the tenancy, including costs associated with processing a new tenant and costs associated with cleaning the property. Application screening fees are not included. The landlord must notify the tenant in writing of the tenant's option to request an initial inspection on termination of the tenancy and the tenant's right to be present at the inspection. If the tenant requests an initial inspection, the landlord must make that inspection before a final inspection, after the tenant vacates, and provide the tenant with an itemized list of potential deductions from the security. The tenant must have the opportunity to remedy identified deficiencies during the period from the initial inspection until the end of the tenancy. The maximum amount of a security deposit for residential properties is 2 months' rent for an unfurnished residential property or 3 months' rent for a furnished residential property. Within 21 days after the tenant has vacated the premises, the landlord must mail the tenant either the full amount of the security deposit or an itemized statement of the basis for the disposition of any of the security deposit and a check for any remaining amount. If the landlord's interest in the property is transferred, the security deposit also is transferred. The tenant is notified by personal delivery or certified mail of the transfer, any claims against the security deposit, and the transferee's name, address, and telephone number. Alternatively, the remaining security deposit can be returned to the tenant along with an itemized statement of the basis for the disposition of any amount not returned. A landlord retaining any amount of the security deposit in bad faith is subject to damages of twice the amount of the security, in addition to the actual loss suffered by the tenant. If any question arises about the validity of a claim, the law presumes that the tenant is entitled to the return of the entire security deposit. The landlord has the burden of proving the reasonableness of the amounts claimed. In fact, the California Civil Code provides that in a lease or rental of residential property, a security deposit can never be labeled non-refundable. Possession by the tenant. The tenant's right to possession is ensured by the covenant of quiet enjoyment made by the landlord, which is implied by law. The covenant refers not to noise but to interference by the landlord in the tenant's possession or use of the property. The landlord could interfere with the tenant's possession by removing the tenant from the property by the eviction process discussed later in this unit. The landlord also could bring about a constructive eviction of the tenant by failing to make necessary repairs after notice from the tenant, interfering with the tenant's legitimate use of the property, threatening to remove the tenant, making unwarranted alterations to the property, or attempting to lease the property to someone else. Landlord's right of entry. The landlord has the right to enter the premises if necessary. The California Civil Code permits such right of entry in the following cases. An emergency. When the tenant has abandoned the premises, pursuant to a court order, so that the landlord can make necessary or agreed on repairs or perform other required services, so that the landlord can show the property to prospective tenants, mortgagees, purchasers, workers, or contractors, The landlord must give the tenant notice of the intended entry unless there is an emergency, and then must notify the tenant immediately afterward, or the tenant has abandoned the premises, or it is impractical to do so. Notice of at least 24 hours is presumed to be sufficient. Tenant improvements. A residential lease usually requires prior approval by the landlord before the tenant makes any alterations to the premises. Subject to negotiation, a commercial lease is likely to require that the tenant make property alterations called tenant improvements, and also may require that the tenant return the property to its original condition on termination. What if a tenant has installed a fixture? If the lease mentions fixtures installed by the tenant, then the lease terms apply. If no prior agreement was made regarding fixtures installed by the tenant and removal of a fixture would damage the property, the tenant may not remove the fixture even at the conclusion of the lease term. If there is no prior agreement regarding fixtures and the fixture can be removed without injury to the property, the tenant may do so if the fixture was installed by the tenant for the purpose of trade, manufacture, ornamental, or domestic use. The best way to avoid conflict is to clarify the status of such items before they are brought onto the property. Transferability. The tenant may need to vacate the premises before the end of the lease term. The landlord may agree to terminate the lease, to increase the rent paid by a new tenant, for instance. A tenant also can transfer possession of leased property by sublease or assignment. Unless prohibited from doing so by the lease terms, the lease could require landlord approval before a sublease or an assignment. The landlord's decision on approval must be reasonable. In a sublease, the tenant transfers possession of the property to another party for only part of the remaining lease term. The original tenant then has a reversion, which is the right to possess the property when it is vacated by the sublessee. The original tenant's interest is also called a sandwich lease. Primary responsibility for payment of rent remains with the original tenant. Internet private residence rental listings. The use of an internet listing platform such as Airbnb by a tenant is considered a short-term property sublease and must comply with the tenant's lease terms. Legislation, beginning with Section 22590, has been added to Division 8 of the Business and Professions Code to clarify the obligations of the hosting platform, which must provide notice to occupants listing a residence for a short-term rental that, if the occupant is a tenant, the rental contract or lease may contain restrictions on the occupant's ability to list the property and the possibility of legal action by the landlord that may include eviction. There must be an affirmative acknowledgement by the occupant of having read the notice before the property can be listed on the hosting platform's internet site. Alternatively, the tenant can make a lease assignment of the entire remaining lease term to another party. In an assignment, the first tenant retains no interest in the property but is secondarily liable for lease obligations unless the landlord agrees to release the first tenant from further liability. Renewal of the lease. The lease usually specifies the procedure for its renewal. It is preferable to have a new lease drawn up for the new term, although the old lease could be extended on the original terms. A lease could provide for an automatic renewal or extension of the lease term if the tenant were to remain in possession after the termination date. All such provisions in residential leases are now voidable by the party who did not prepare the lease unless the automatic renewal clause is printed in at least 8-point boldface type and. The existence of the automatic renewal provision is noted directly above the space provided for the tenant's signature, again in at least 8-point boldface type. Landlord's obligations. As a minimum, the landlord must follow all applicable housing or building standards. Even if there is no express provision in a lease agreement, there is a legally implied warranty of habitability. The California legislature has specified in the Civil Code the conditions under which a dwelling will be considered untenantable. Covenant to repair. In most lease agreements, the landlord expressly covenants promises to make necessary repairs to the premises. If there is no express promise to repair, a court may find an implied covenant to repair, depending on the nature of the work required. Residential tenants' remedies. To whom can a tenant complain? The local building inspection department, health department, or fire department will receive tenant complaints on applicable violations of state or local building, fire and safety, and other standards. The tenant's complaint will be investigated, and the landlord will be required to make necessary repairs. If a residential landlord won't make repairs that are necessary to make the property tenantable, livable, the tenant is allowed to make repairs to the property. The tenant must give written or oral notice of the needed repairs to the landlord or the landlord's agent, then wait a reasonable time, 30 days for example, depending on the circumstances, for the landlord to act. After that time, if the landlord has not acted, the tenant can spend up to 1 month's rent on repairs. The tenant may not repair and deduct more than twice in any 12-month period. A landlord is not allowed to retaliate against a tenant who complains. A landlord is not allowed to penalize a tenant who complains to an appropriate agency about the condition of the premises or who uses rent money for repairs. Actions considered penalties include retaliatory eviction, increasing rent, or decreasing services. If the landlord does retaliate against the tenant and the tenant is not in default in payment of rent, the landlord may not recover possession of the premises, cause the tenant to quit the premises, increase rent, or decrease services for 180 days from notice of the complaint or needed repair. If the landlord fails to make a necessary repair, the tenant also may sue the landlord for breach of the warranty of habitability. Or the tenant could simply abandon the premises with no further obligation to pay rent or otherwise comply with the lease terms. The tenant should seek competent professional advice before taking either action, however. An untenantable dwelling. California law defines an untenantable dwelling as one that substantially lacks any of the following: deadbolt lock on each swinging entry door, security or locking device on every window designed to open, adequate weatherproofing including unbroken windows and doors, plumbing or gas lines that conform to local building codes when installed and have been maintained in good working order, hot and cold running water with fixtures and sewage disposal system approved under applicable law, heating facilities that conform to applicable law when installed and have been maintained in good working order, electrical lighting with equipment and wiring that conform to local building codes and are maintained in good working order. Building and grounds clean, sanitary, and free of debris, rubbish, rodents, and vermin at the time the lease term begins, with areas under the control of the landlord to be so maintained during the lease term. Adequate trash receptacles provided in clean condition and good repair, and so maintained by the landlord when under the landlord's control. Floors, stairways, and railings maintained in good repair. Commercial tenants' remedies. There are important exceptions to a commercial tenant's remedies, for a commercial tenant is regarded as being in a better bargaining position than a residential tenant. At present, the courts generally do not allow a commercial tenant to repair and deduct. A commercial tenant can bring a lawsuit against the landlord for breach of warranty rather than use the breach as a reason for non-payment of rent. The commercial tenant also may treat the breach as a constructive eviction, vacate the premises, and sue for damages. Tenant's obligations. In addition to paying rent, the tenant must care for the leased property and use it appropriately. The tenant's duties are specified in the California Civil Code. The tenant must keep the premises as clean and sanitary as conditions permit. Rubbish and other waste must be disposed of in a clean and sanitary manner. The landlord could agree in writing to undertake the duties of maintenance and waste disposal. Tenant's obligations. The tenant must use all electrical, gas, and plumbing fixtures properly and keep them as clean and sanitary as conditions permit. Neither the tenant nor any person on the premises with the tenant's permission may deface, impair, or remove any part of the structure or its equipment. With regard to a dwelling place, different portions of the property may be used by the tenant only for the purposes for which they were designed and intended. For instance, only the kitchen may be used for cooking. Landlord's remedies. If a tenant is in substantial violation of the tenant's obligation to use ordinary care to maintain the premises, a residential landlord has no duty to make resulting necessary repairs. The lease could give the tenant the duty to repair, but if such repairs are not reasonable, the landlord will be unable to sue for damages if the repairs are not made. Breach of lease terms also may give the landlord grounds for terminating the lease and evicting the tenant if necessary. Liability of landlord and tenant. A guest in a leased building trips on a piece of loose tile flooring, falls, and breaks their arm. Who is liable for damages arising from the defective condition of the premises? Under certain conditions, the landlord, tenant, or both could be liable for injuries suffered on the premises by anyone, whether tenant, an invited guest, someone permitted on the premises, such as a meter reader, or even a trespasser. The landlord of residential property may be liable under a negligence theory for injuries to tenants that result from the defective condition of the premises at the time the tenant takes possession, if the landlord failed to correct the defect. The landlord's liability generally extends to damages that arise from injuries caused by defective conditions in the leased real estate that the landlord knew or should, with reasonable diligence, have known about. Even after the tenant takes possession, the landlord must repair defects that are brought to the landlord's attention. The landlord also is charged with the condition of public areas or areas over which the landlord retains control, such as hallways, stairways, and elevators. Exercise. Who usually bears responsibility for each of the following in a residential apartment building? Termite infestation. Hole in plaster wall, made by guest of tenant. Injury suffered by guest who trips over tenant's coffee table. Insufficient lighting in common hallway. Broken main entry door to building. Window broken by present tenant. Window broken by previous tenant. Trash pickup from outside receptacles. Removing trash from premises. Injuries to trespasser who falls through floorboard weakened by tenant's bathtub overflow that was never reported to the landlord. Discriminatory acts. California's Fair Employment and Housing Act, FEHA, found in the Government Code, prohibits housing discrimination based on marital status as well as race, color, religion, sex, including gender identity, sexual orientation, national origin, ancestry, familial status, age, disability, physical or mental, medical condition, or source of income. The Department of Fair Employment and Housing enforces the law, which is based on the former Rumford Fair Housing Act. California Civil Rights Housing Act of 2006 provides that, as of January 1, 2007, all of the protected classifications of FEHA are extended automatically to all other non-discrimination laws. This includes the UNRRA Civil Rights Act, discussed next. The UNRRA Civil Rights Act, found in the California Civil Code, now forbids discrimination as to race, color, religion, ancestry, national origin, familial status, age, disability, physical or mental, medical condition, marital status, sex, including gender identity, sexual orientation, and source of income in accommodations and business establishments. Under the UNRRA Act, there can be no arbitrary eviction, rent increase, or withholding of services by virtually any landlord, including the owner of a non-owner occupied single-family dwelling that is sold or leased for income or gain. An exception to the prohibition of discrimination based on age is made for housing designed to meet the physical and social needs of senior citizens. California Civil Rights Housing Act of 2006 provides that, as of January 1, 2007, all of the protected classifications of FEHA are extended automatically to all other non-discrimination laws. This includes the UNRRA Civil Rights Act, discussed next. The UNRRA Civil Rights Act, found in the California Civil Code, now forbids discrimination as to race, color, religion, ancestry, national origin, familial status, age, disability, physical or mental, medical condition, marital status, sex, including gender identity, sexual orientation, and source of income in accommodations and business establishments. Under the UNRRA Act, there can be no arbitrary eviction, rent increase, or withholding of services by virtually any landlord, including the owner of a non-owner occupied single-family dwelling that is sold or leased for income or gain. An exception to the prohibition of discrimination based on age is made for housing designed to meet the physical and social needs of senior citizens. A leaser brings an action to evict a leasee from a rental property because the leasee has numerous tattoos, receives public assistance, and is a student. The leaser will not be successful because all of those reasons are arbitrary and fail to establish good cause for an eviction. The same act of discrimination can violate both state and federal law. Since 1968, federal law has expressly prohibited public and private discrimination based on race, religion, or national origin or ancestry in the sale, rental, or lease of housing. Discrimination based on sex was prohibited in 1974. With the passage of the Fair Housing Amendments Act of 1988, discrimination on the basis of handicap or familial status, age, is also prohibited. For example, some years ago, a leaser tried to evict a tenant because the tenant was living with an unrelated adult. The leaser was unsuccessful because the intended action violated what was then the Rumford Act. The leaser recently decided to require that each member of an unrelated couple living together in one of the apartments meet rental financial requirements, even though married couples can aggregate their income to meet the financial requirements. Can the leaser do that? No. The Fair Employment and Housing Act bans discrimination based on marital status. Note, discrimination under FEHA does not include refusal to rent part of a single-family, owner-occupied dwelling to only one individual. All notices and advertisements must comply with FEHA, except for those expressing a preference for applicants of one sex for the sharing of living areas in a single dwelling unit. Termination of the lease. There are various ways by which a lease may be terminated, both with and without the consent of both parties. Expiration of the lease term. The lease should specify a termination date or the length of any notice that must be given to the other party before termination. A lease for a definite term terminates at the end of that term, even without notice. A periodic tenancy, usually month to month, may be terminated by the landlord or tenant on notice equal to the lease period, but not more than 30 days before the date of termination. If a tenant fails to give adequate notice of termination, additional rent may be owed even if the premises are vacated as of the end of the lease term. If both parties agree, notice to vacate may be shorter than 30 days. A residential tenancy requires a 60-day notice if the tenant has resided in the dwelling for 1 year or more. A tenant at sufferance need not be given advance notice. The death of landlord or tenant automatically terminates a tenancy at will or tenancy at sufferance. It does not terminate a tenancy for a definite term unless the lease provides otherwise. Under Section 1946.7 of the Civil Code, special notice requirements apply if a residential tenant who intends to terminate a tenancy is a victim of domestic violence or sexual assault. The notice requirement is just 14 days if the tenant attaches to the written notice to terminate a copy of either a temporary restraining order or a protective order that protects the tenant or household member from further domestic violence or sexual assault. A report by a peace officer stating that the tenant or household member has filed a report alleging that person or the household member has filed a report alleging the person or household member is a victim of domestic violence or sexual assault, or documentation from a qualified third party based on information received while the third party was acting in a professional capacity, indicating that the tenant or household member is seeking assistance for physical or mental injuries or abuse resulting from an act of domestic violence, sexual assault, stalking, human trafficking, elder abuse, or dependent adult abuse. Surrender of the leasehold estate. The lease interest can be given up by a surrender of the leasehold. This will happen if both parties consent to it, or if one of them acts in a manner inconsistent with the existence of the lease, such as the landlord leasing the property to someone else. Grounds for termination by tenant. Either landlord or tenant may have grounds for termination of the lease without the other's consent. A lease may be terminated by a tenant in the following situations. The landlord has violated the tenant's right to quiet enjoyment possession. The landlord has violated the duty to repair. The landlord otherwise has failed to keep the premises habitable. The landlord evicts the tenant. The landlord breaches a condition of the lease. The premises are destroyed and there is no covenant to repair. The property is taken by eminent domain. If only part of the property is taken, the lease will be effective as to the rest unless a court determines the remaining property is unsuitable for its leased purpose. Grounds for termination by landlord. The Tenant Protection Act of 2019 TPA in Civil Code Section 1946.2 prohibits the termination of a residential tenancy if there is not just cause for the termination when the tenant has continuously and lawfully occupied the property for 12 months. If an additional adult tenant occupies the property before it has been occupied by the existing tenant for 24 months, the requirement for occupancy is extended to 24 continuous months by at least one of the tenants or 12 continuous months for all of the tenants. Just cause can be at fault or no fault. At fault causes include default in payment of rent, breach of a material term of the lease, tenant created nuisance or waste, use of the premises for unlawful purpose or commercial activity, refusal of the tenant to allow the owner lawful entry, or tenant's refusal at end of lease term to sign an extension or renewal of the lease on similar terms, subject to TPA. No fault causes for termination of a residential lease by the landlord include owner move in situations in which the owner or owner's family intends to occupy the property and for a lease entered into after July 1st, 2020, either the tenant agrees to vacate or there is a provision in the lease that allows the owner to terminate in such a case. The owner intends to withdraw the property from the rental market. A government agency requires the property to be vacated. The owner intends to demolish or substantially remodel the property by performing work that is more than cosmetic. With a no-fault termination for just cause, the owner must assist the tenant in relocating by waiving payment of rent for the final month of the tenant's occupancy, or must pay the tenant 1 month's rent. The just cause requirement does not apply to housing restricted as affordable housing, dormitories. New housing issued a certificate of occupancy within the previous 15 years, a rolling calculation that applies back to 2005 and 2020, 2006 and 2021, and so on. Single-family residences, provided the tenants are notified of the exemption and the property is not owned by a corporation, limited liability company, when at least one member is a corporation, or real estate investment trust. Single-family owner-occupied properties in which no more than 2 bedrooms units are rented, including accessory dwelling units. Owner-occupied dwellings if the owner and tenant share a bathroom or kitchen. Duplexes in which the owner occupies one of the units. Transient and tourist hotel occupancy. Housing accommodations in a nonprofit hospital, religious facility, or extended care, elderly, or adult residential facility, and residential real property subject to a local ordinance requiring just cause for termination that was adopted on or before September 1st, 2019. If adopted after that date and more protective than state law, the local ordinance will apply. Request for demolition. California requires the owner of a residential dwelling unit or the owner's agent who applies to any public agency for a permit to demolish the unit to give written notice of the request to current tenants before applying for the permit. Notice of the request must be given to prospective tenants before entering into or initiating a rental agreement. The notice must include the earliest possible approximate date the owner expects the demolition to occur, as well as the approximate date the owner will terminate the tenancy. If a landlord fails to provide the required notice, a court may award a tenant actual damages and moving expenses, in addition to a civil penalty not to exceed $2,500 and reasonable attorney's fees. Abandonment. Abandonment is the tenant's voluntary relinquishment of the premises without the landlord's express or implied consent and with no intention to perform future lease obligations. The landlord's express or implied consent would make the relinquishment a surrender rather than an abandonment. If rent is owed for at least 14 days and the landlord reasonably believes the tenant has abandoned the premises, the landlord can establish the fact of abandonment by giving written notice of that belief. The tenant must respond in writing within 15 days after personal service of the notice or 18 days after receiving a mailed notice, denying any intent to abandon the property and giving the landlord a forwarding address where he can be reached. Notice is not strictly necessary, but it is a wise precaution that will protect the landlord if the tenant shows up later. Abandonment notice can be given in addition to any other notice and may be the fastest way to establish the landlord's right to retake possession of property. Eviction. Eviction is the process by which a tenant can be removed from the lease premises. The landlord must first notify the tenant of the breach of the lease or other unfulfilled obligation. Notice. If the tenant has not paid the required rent, the landlord must first give 3 days written notice to pay or quit, requesting compliance with the lease terms or property relinquishment. Similar notice is given if the tenant has breached some other lease provision. If an illegal sale of a controlled substance has occurred on the premises, the landlord can give a 3-day notice to quit without providing for the option to cure the misconduct. If drug activity can be proven, city attorneys and district attorneys can evict tenants within the cities of Long Beach, Los Angeles, Oakland, and San Diego. If notice to terminate is given as discussed earlier, the notice period will be the period specified in the lease, the period of tenancy, or 30 days. In a periodic tenancy, the notice period is 30 days unless the lease specifies a shorter period, which must be at least 7 days. Even when a tenant has breached such a lease, by not paying rent, for instance, the landlord may choose to use the 30-day notice to prevent the tenant from paying the rent and curing the breach. The landlord also could give both forms of notice. Notice must be written and personally served on the other party, or, in the tenant's absence, on a suitable person at the tenant's residence or place of business. If served on a third party, notice also must be mailed to the tenant at the tenant's residence address. If no residence or business address is known, notice must be placed in a conspicuous place on the leased property and also mailed to the tenant at the property location. Notice. Government-owned or subsidized housing. Special notice requirements apply for rental housing owned or subsidized by a government agency. In 2005, the California Supreme Court held in Wasatch Property Management versus DeGrate that Section 8 public housing tenants are entitled to a 90-day notice of lease termination. An action to evict such a tenant requires good cause to evict or an administrative hearing to determine whether there is good cause to evict. At the hearing, the tenant can be represented by an attorney. The tenant also has the right to have the hearing conducted in private. 3-day notice to pay rent or quit unlawful detainer. If the tenant fails to comply after notice to pay or quit has been given, the landlord can sue for rent owed, which does not terminate the lease. The landlord also can request an order of eviction from the court by a legal proceeding called unlawful detainer. If the court decides in favor of the landlord, and if the notice to the tenant stated the landlord's intention to declare a forfeiture of the lease will be forfeited. The tenant will be liable for damages, such as rent owed, up to the date of the court's judgment or the date the landlord retakes possession of the premises. If the landlord failed to include a statement of intention to declare a forfeiture in the notice, the tenant's liability for damages is up to the court's determination. A landlord of residential property may not cause disruption or termination of the tenant's utility service, even if the right of eviction has been granted. Tenant's response. The tenant can defeat the unlawful detainer action if proper notice was not given. The landlord's action is retaliatory. The alleged facts are not true. The landlord's action is arbitrary, without good cause, or there is some other legal barrier to the eviction, such as a violation of the UNRRA Act. Tenant's response. A tenant may willfully and maliciously remain in possession of leased premises after the expiration or termination of the lease term, in what is called a holdover tenancy. In that case, the tenant is liable to the landlord for 3 times the amount of rent and any damages due, as punitive damages. An unlawful detainer is not the only legal action that can be brought by a landlord against a tenant, but it may be the quickest way to regain possession of leased premises. Courts must give unlawful detainer suits precedence over all other cases, except criminal cases, in setting a court date. Lessor and lessee frequently settle their differences before a trial. The landlord may forgive part or all of the rent owed, or even pay the tenant's moving expenses in exchange for a prompt vacancy. If the tenant has proof of some breach by the landlord, it is more likely that concessions will be made. Writ of possession. The landlord who succeeds in an unlawful detainer suit can be awarded rent arrearages, damages caused by the unlawful detention, and possession of the leased premises. If possession is granted, the clerk of the court issues a writ of possession that directs the sheriff or marshal to take all legal steps necessary to remove the tenants from the premises. The sheriff or marshal executes the writ by serving it on one occupant of the property. Service is accomplished by leaving a copy of the writ with the occupant or an employee or agent of the occupant or a suitable member of the occupant's household. If that is not possible, a copy of the writ is posted in a conspicuous place on the premises, and another copy is served personally or by mail to the judgment debtor. 5 days after the service, the sheriff or marshal may remove any occupant still on the premises, unless the occupant is not named in the writ and claims possession, or a right to possession that stems from before the time at which the unlawful detainer action was filed with the court. Stay of execution. The tenant may receive a stay of execution of a judgment in favor of the landlord for 5 days to pay back rent and have legal possession restored if the reason for the eviction is non-payment of rent. The lease would not have expired otherwise, and the termination notice did not declare the forfeiture of the tenant's lease rights. The trial court also can stay execution of the judgment under its own authority. Tenant's personal possessions. An inventory must be made of any of the tenant's personal possessions left behind when the tenant vacates the premises. The inventory is made or verified by the sheriff or marshal. The landlord must store the possessions for 15 days from the date notice is personally delivered or 18 days after mailing, during which time they can be reclaimed on payment of reasonable storage fees. If unclaimed, they may be sold at public auction and the proceeds applied to storage and sale costs. Any remaining sale proceeds in security or other deposits must be returned to the tenant. Mobile home tenancies. Laws applying to mobile homes appear in many California Code sections. Some of the most important provisions are mentioned here. Mobile Home Residency Law. The Mobile Home Residency Law MRL, Civil Code sections 798 to 799, regulates manufactured home, mobile home rental agreements, charges, grounds for eviction, and eviction procedures. The MRL defines a mobile home park, homeowner resident, and tenancy to which the law is applicable. General landlord-tenant laws apply to manufactured housing, except where they are preempted by specific laws regarding such homes. Applicability. The MRL applies to agreements between 1. Mobile home park management and the resident of an owner-occupied home, and 2. Mobile home park management and a non-resident owner who rents a home to someone else. In the latter case, the agreement could include provision for subletting. Agreements between park management and the resident of a park-owned home are not included in the MRL, although for the sake of uniformity similar provisions should be used. Parks are subject to the same provisions against discrimination that apply to other residential landlords, although the type and size of homes within a park can be controlled. Fees. The prescribed lease form includes any fees to be paid by the tenant, although an additional fee can be imposed after 60 days written notice. Fees are limited to rent, utilities, and incidental reasonable service charges. Termination. The MRL states the following as the only permitted reasons for termination of a lease by mobile home park management: non-payment of rent, utility charges, or reasonable incidental service charges; failure to comply with reasonable park rules or regulations as set out in the rental agreement or amendments; conduct by the homeowner or resident on park premises that is a substantial annoyance to other homeowners or residents; failure of homeowner or resident to comply with applicable laws and ordinances within a reasonable time; condemnation of the park; change of use of the park. Notice. If a tenant has not paid rent, utility bills, or other fees for at least 5 days from their due date, termination proceedings may begin. A written notice to pay or quit must be made, allowing 3 days for payment to be made. Written notice of termination must be given 60 days before the termination date. A copy of the notice must be sent to the registered mobile home owner and junior line holders within 10 days of service on the homeowner. Notice of termination can be given at the same time as notice to pay or quit, but payment within the 3-day period will satisfy both. The registered homeowner, if not the same as the resident, the legal owner, if there is a deed of trust on the property, and any junior line holders have 30 days after the notice of termination is mailed in which to cure the default, but may do so no more than twice during a 12-month period. If the homeowner or resident has not complied with reasonable park rules, a 7-day written notice to comply must precede the 60-day notice of termination, unless 3 such notices already have been given within a 12-month period. Other notice provisions apply if the termination is due to a change of use of the park in which the home is located. Exercise. What is the minimum notice or other time requirement for each of the following? Notice by the tenant to terminate a month-to-month tenancy. Tenant's denial of abandonment of premises. Notice to pay or quit. Enforcement of writ of possession. Storage of tenant's personal belongings after eviction. Notice to pay or quit under MRL. Notice to terminate under MRL. Other lease arrangements, lease option. A lease can serve many purposes. A lease option, unlike an option alone, conveys the right of possession as well as the option right. In residential transactions especially, the lease option can be a way to ensure a subsequent purchase, particularly if part of each lease payment is applied to the eventual down payment. A notice of termination can be defeated by payment, but only twice in a 12-month period. Commercial leases. In the typical gross lease, the tenant pays a fixed amount for rent over the lease term. In turn, the landlord pays all expenses of ownership, such as taxes, assessments, and insurance. An escalator clause in a lease may provide for an increase in payments based on an increase in an index such as the Consumer Price Index, CPI, or the Wholesale Price Index, WPI. This type of lease is called a graduated lease. With a percentage lease, both landlord and tenant share in the success of the tenant's business. With a net lease, the landlord is guaranteed a specific net income because the tenant pays that amount plus some or all of the operating and other expenses, such as taxes, insurance, assessments, maintenance, and other charges. The tenant's obligations are stipulated in the lease agreement. A net lease also can be referred to as a triple net lease or 3N lease because the tenant pays the taxes, insurance, maintenance, and other charges. Other lease terms. As a result of the terrorist attacks of September 11th, 2001, issues that are now of concern, particularly with well-known buildings, include access control and security, including admittance to the building, parking, and mail and other deliveries. They are subject to negotiation between landlord and tenant but should be covered. Commercial lease rent payments also may be based on the income earned on the lease premises. In a percentage lease, the rent is a percentage of the tenant's gross income, usually with a minimum base amount. As income increases, the percentage typically decreases. Property management. Any type of property from a single-family residence to a 1,000-unit office building can be managed by an agent of the owner. The size of modern structures and widespread holdings of some investors have made property management a growing specialty in the real estate field. The resident property manager. In California, every building with 16 or more dwelling units must have a resident apartment manager. By living on the premises, the resident manager helps ensure that tenant complaints are handled promptly. Duties of the property manager. An on-site resident property manager or professional management firm or individual with a real estate broker's license can act as the owner's agent too. Lease units. Collect rents. Maintain communication with tenants and conduct all day-to-day business necessary to maintain the property. The property manager ordinarily earns a fee based on the income the property produces in rents. The property manager also may receive a separate fee for such activities as supervising alterations or remodeling. Qualifications of the property manager. Real estate brokers can be property managers, but sound business practice as well as ethical considerations require that they be adequately prepared before offering their services as property managers. Knowledge of contracts, lease requirements, building operation, maintenance, and other aspects of property management, including the people skills necessary to deal with tenants, must be learned by training, study, or experience. Property management agreement, see brain food. Rent control. Rent control is imposed by state law or ordinance of a local governing body to protect tenants from relatively high rent increases over the occupancy period of a lease. Types of rent control. There are two types of rent control in California based on whether a new tenant benefits from existing rent protection. With vacancy decontrol. If a rent control law contains a vacancy decontrol provision, when a unit becomes vacant, there is no restriction on the rent set for a new tenant. After the premises have been leased again, the new rent becomes the new base amount and is again subject to controls, without vacancy decontrol. A rent control law without a vacancy decontrol provision limits rent increases for new tenants as well as for existing ones. State law. The Costa-Hawkins Rental Housing Act preempted local rent control laws on the following. New units with a certificate of occupancy issued after February 1st, 1995. Single-family detached houses and condominiums. Multi-unit dwellings in areas with vacancy control except where the tenancy is terminated by the landlord's service of a termination notice or a change in the tenancy's terms from January 1st, 1996 through December 31st, 1998 after a voluntary vacancy, abandonment, or eviction based on non-payment of rent on one of these units. Landlords were allowed to increase rents by the greater of 15% or up to 70% of the prevailing market rate for a comparable unit. 2 rent increases were allowed during the initial 3-year period. As of January 1st, 1999, there were no limits on allowable rent increases for new tenancies and tenancies created on or after January 1st, 1996. That state of affairs changed with the signing into law of the Tenant Protection Act of 2019, TPA. As of January 1st, 2020, TPA, in Civil Code Section 1947.12, prohibits an owner of residential real property from increasing the gross rental rate charged for a dwelling unit by more than 5% plus an inflation factor over the lowest gross rental rate charged for that unit in the previous 12 months. In no event may the increase exceed 10% or involve more than 2 incremental increases over the 12-month period. The rent increase cap does not apply to the establishment of the initial rental rate for a new tenancy in which no tenant from a prior tenancy remains in lawful possession. State law has greatly reduced the impact of rent control. The cap imposed by the new law applies retroactively to all rent increases occurring on or after March 15, 2019. Tenants of single-family residences must be provided with a specified written notice if the property they occupy is exempt from the new law. For tenancies that begin or are renewed after July 1, 2020, the required notice must be included in the rental agreement. The new rent increase cap does not apply to housing restricted as affordable housing, dormitories, new housing defined as housing that has been issued a certificate of occupancy within the previous 15 years. As with the just cause termination requirements, this is a rolling calculation that applies back to 2005 and 2020, 2006 and 2021, and so on. Single-family residences, provided the tenants are properly notified of the exemption and the property is not owned by a corporation, limited liability company when at least one member is a corporation or a real estate investment trust, and duplexes in which the owner occupies one of the units. Credit reporting. Permission for the landlord to obtain a prospective tenant's credit report is usually a requirement of a lease application. The requirements of both state and federal law must be followed with regard to the use of the report, as well as information on tenants provided to credit bureaus by the landlord. The Federal Fair Credit Reporting Act, FCRA, was amended by the Fair and Accurate Credit Transactions Act of 2003, FACTA, to include protections for those whose identity is stolen. If an identity theft report has been made by a tenant, for example, a landlord is not allowed to report delinquent rent to a credit bureau. Information on FACTA can be found at ftc.gov. State law is found in California Civil Code Section 1785. Exercise. C. A computer technician wants to lease a storefront for a new business, Classy Computers. In addition to selling computers, C will also be conducting classes in computer and internet use. C approaches the owner of a vacant unit in a small strip shopping center in a high-traffic area near a community college. The owner is impressed by C's business plan and agrees to lease the space. The owner is interested in helping C become established and also in benefiting from the expected growth of C's business. What kind of lease would best accomplish the aims of both parties? Summary. A lease is a form of contract transferring a less than freehold estate the right to property possession and use, but not ownership. The landlord conveys the leased premises to the tenant. The tenant pays rent in consideration for the lease. A security deposit may also be required. If rent is unpaid, the landlord has the ultimate remedy of eviction. A written lease agreement may be required by law, and it always is preferable. A lease follows the same formalities as any other contract. A statement of property condition at the time the lease begins will help when the tenant vacates the premises. If the tenant's right to quiet enjoyment of the premises is interfered with by the landlord, the tenant may complain of a constructive eviction. The landlord has only a limited right of entry to the leased premises and usually must give notice to the tenant first. The tenant may be able to sublease or assign the right of possession granted by the lease. There are strict requirements for automatic renewal of leases. The landlord makes an implied warranty of habitability and an express or implied covenant to repair the premises. Certain minimal requirements must be met or the property will be considered an untenantable dwelling. If the landlord fails to meet those responsibilities, the tenant can complain to the appropriate authorities, withhold rent to make necessary repairs the landlord has not made, sue the landlord, or abandon the premises. The tenant must also maintain the premises and cannot expect repairs from the landlord for damage resulting from the tenant's own negligence. Both landlord and tenant may be liable to persons injured on the premises if the premises are under their control and they fail to exercise ordinary care. A landlord may be liable for injuries to a tenant of residential property caused by the defective condition of the premises. Discrimination in accommodations in business establishments is forbidden by the Unruh Civil Rights Act. Discrimination in housing is forbidden by the California Fair Employment and Housing Act. Federal prohibitions against housing discrimination also apply. California's Civil Rights Housing Act of 2006 extends all of the protected classes of FIHA to all other non-discrimination laws, including the UNRRA Civil Rights Act. Notice may be required to terminate a lease. The leasehold estate could be surrendered by agreement of the parties. There are specific grounds for termination before the lease term ends, and the tenant could abandon the premises. Eviction can be carried out only by a prescribed procedure, including notice to the tenant. An unlawful detainer is the legal action that can result in a writ of possession directing the sheriff or marshal to remove the tenants from the premises. Manufactured home rentals have certain unique requirements, although they basically follow general landlord-tenant law. Other types of leases can range from the lease option to the net lease used in commercial transactions. Property management is an important and growing area of real estate professionalism. Rent control in several forms exists in communities throughout the state. Legal counsel must be consulted for particular requirements of individual ordinances as well as state law. Credit reporting practices have come under increasing regulation, particularly with the growing threat of identity theft.